Well, we were given liberty to file a fresh writ petition before the single bench. We filed that. Your lordships have issued notice. Now, pursuant to the orders passed by the district council, my lords, the petitioner who was the Mintri from the Nonklau clan, my lords, he has been suspended without any notice to him. We filed a fresh writ petition, my lords. We've served copies, but it's not getting listed. If I may pray, your lordship may kindly take it at the end of the board as an unlisted matter, my lords.
Tomorrow?
It's Saturday, my lords.
Cannot wait till Monday.
Your lordships, please, my lords,
Always safe to have it listed before this.
my lords, let it be on Monday.
Supply the copy to the other side.
Already served, my lords. Including, there's a caveat, we filed copies. Obliged.
Lordship, I seek legal accommodation, Lordship. Item number 10, Lordship. Item number 10, Lordship. The matter was heard on the appellant side on the last date, Lordship. Today I have some difficulties today, Lordship. Item number 10, Lordship.
Yes, Lordship.
When do you want it?
After 2 weeks, Lordship.
Attempt 10 after 2 weeks on the request made on the status warrant.
Must apply.
May I please, Your Lordship, I beg to mention item number 12.
Yes.
I pray for 2 weeks' time, Your Lordship.
No objection, Your Lordship.
12, 2 weeks on the request made on behalf of the petitioner.
Much polite, Your Lordship.
Lordship, I beg to mention item number 7. Lordship, conducting counsel is unable to take up the matter due to personal difficulty. So this matter may come up after 3 weeks, 2 weeks, Lordship.
Who is the petitioner here?
Petitioner is
Seven and eight. Because they are connected.
connected
Who is the
matter.
petitioner? Who is the petitioner?
Petitioner, Mr. Bidep.
So where is he? Inform him. Just let us see whether he has any objection or not. Because we just cannot pass an order in absence of petitioner.
Yesterday he informed me that he is also taking time in this matter.
So it's all about then. Do you want it to be recorded? No, we cannot record it like this. Just wait, just see, just locate them and just make a mention.
Yes,
Yeah, please, Your Lordship. Your Lordship, I beg to mention item number 11, Your Lordship.
Yes,
I pray if this matter can be passed over for a day, Your Lordship.
for the day.
Yes, Your Lordship. I've informed the council the other side, Your Lordship.
The respondent.
Yes, Your Lordship. Sometime next week, Your Lordship.
But then why nobody is present? Why? At least they should have the courtesy to, you see, like, to be present. Otherwise, their name will not be reflected, and it will be shown that none appears. Then it will be a problem. You have already informed the other side,
Yes, Your Lordship.
but then it will go after. It will not say possible. It will be after review.
Yes, Your Lordship.
11, just say in the London Council. Just record his name for the petitioner. Submits. Please for grant of time. Grant of 1 week time. 1 week's time in the matter. He submits that the respondent has already been informed before the prayer for adjourning the matter has been made. Prayer alert list for a week.
Highly obliged, Your Lordship.
May it please, Your Lordship. Lordship, I'd like to make a mention of item number 6, Your Lordship.
Yes. Other side, where is the other side?
Lordship,
Please,
I've already
before you
informed.
mention, please inform the other side.
Your Lordship, I've already informed.
Where are they? At least make somebody stand up, mister. It seems like what
Well,
happened?
I'm so sorry, my lord. I was not aware the
Cases
matter
are
would be
called,
mentioned.
counsels are not there.
I was not aware the matter would be mentioned. Well, this matter, my lord, in fact, This is a conviction on the by this PSF security court, my lord. But I've been inside for 3 years. I've been punished for 7 years, my lord. Almost half the sentence has I've served.
To be punished under what section of law?
My lord, under civil offence, my lord. Basically, an FIR was lodged, but the BSF wanted to try me according to their own rules. So, my lord, under the provisions of the BSF rules, I was tried by the BSF court. Now, upon completion of trial, my lord, they came to a finding I'm guilty of an offence.
Under?
My lord, otherwise under 376 of IPC, my lord. But my lord, here almost 3 years I've been inside. So, my lord, if we cannot take up the hearing, my lord, I have also filed an application for suspension of sentence.
That also
That
will-
may be considered, my lord.
That also will have to take hearing.
Well, absolutely,
hearing
my
for
lord. Absolutely,
deciding.
my lord. Because, my lord, if in many cases, my lord, I can place judgments also where,
We say, supposing, will there be any logic of adjourning the main case and taking up the
my
other
lord, in case they are not willing to take up the main matter, then, my lord, at least I am
not
I am
willing to-
inside for 3 years.
You are making a mention for adjourning the main matter, ready to take up the interim matter.
I think they are making a mention for both the matters.
It is
Well,
not
just a
that-
week's time, my lord, that in that case. Otherwise, we can hear the application on suspension of sentence at least, my lord. I will satisfy this court, my lord, if
For
almost
whatever
half.
reason the matter will have to be taken up, whether
Absolutely,
it's
my
for
lord.
consideration of the interim prayer or for final. And then since the matter this is 2022 matter,
22, my lord.
so what is the question? We'll go for finally.
My lord, in fact, 22, my lord, because for post confirmation they took some time, my lord. In fact, I was convicted. Thereafter, my lord, they took almost 8 months to confirm. Without post confirmation, I could not come before the court and challenge the finding. So, my lord, now I have been inside for 3 years. More than 3 years, in fact, my lord. If we take the pre-trial detention into consideration as well. So, my lord, we can hear this next week, my lord. If not the entire matter, then, my lord, at least lordship will hear.
There is no question of deciding it now on interim thing. We'll just go for final. You just agree on a thing and then just take it up.
Next week, then, my lord, in that case.
I'm praying for 2 weeks, Lordship.
My, well, in fact,
If there is any objection, then it becomes difficult. Madam.
because, my lord, the fact remains my liberty is curtailed.
Sorry, the court is not very much inclined. Then we'll take up the matter.
Okay, Lordship.
Next week, my lord, in that case, at least a week's time, not more than that.
The respondent prays for adjournment of the matter by 2 weeks. Stop. The prayer has been opposed vehemently by the learned counsel for the petitioner. However, for ends of justice, the matter is urgent for 1 week. List accordingly.
Much obliged,
It will come after a week.
my lord. Much obliged.
Similar prayer for item number 6 as well. Similar prayer for item number 9 as well, Your Lordship.
Here you are petitioner.
Yes, Your
Well,
Lordship.
it's the CBI has come.
There is no interim order.
No, Mullins.
So any objection?
Well, it's my learned friend once, 2 weeks.
2 weeks.
Well, the only thing is that, in spite of that not being any interim order, since there were criminal proceedings against the respondents here in Mullins, the accused before the learned trial court, one of them has retired in the meantime. Mullins, his pensionary benefits are not being released, and 2 other accused persons whom I represent
This is
before
because the pendency.
Mullins.
No, how can that situation be held by this court?
Mullins, there is no official communication. They simply say,
If the department misinterprets certain situation, then which way this court can help it?
Mullins, only prayer is my friend wants 2 weeks. Mullins, let it be finally heard after 2 weeks. We can try and close this matter.
It is there the other in the hearing column, and you know, like
Mullins.
normally the court doesn't have any shortage of time.
Balance.
Any time counsels are ready, we can take up matter.
Mullins.
So we can adjourn it for 2 weeks.
Mullins.
Just say. List this matter after 2 weeks on the request of the. And just this appearance will come, that will be recorded.
Mullins.
Don't worry.
Obliged.
Much obliged, Lordship.
After 2 weeks on the request of the. Yes.
Should I beg to mention item 7 and 8? The connected matters, my lord.
Yes. Who
7
was
and
making a mention now?
7 and 8.
Earlier, who was making mention? 7 and 8. You were making. When do you want it?
After 2 weeks, my lord. After 2 weeks, lordship.
Just on the joint request of the parties. This is matter after 2 weeks. 2 weeks is all right.
Yes, 2 weeks.
7 and 8.
7
Joint request of parties. Yes. Yes.
Supplementary causes. Item number 1.
May it please your lordship. Your lordship, this is the case petition I filed under 482 CRPC, your lordship, for quashing the proceedings, which is pending before the principal presiding officer.
POXO matter.
No, it's not POXO, your lordship. It's not POXO. It's pending
We
before.
have most of the quashing matters in POXO cases.
No, your lordship. This is under section 354, 354A, 323, and 506, your lordship.
This is not compoundable.
354 and 354A is not compoundable. 323, 506 both are compoundable, your lordship. But only this 354, where the punishment is extended up to 3 years, and 354A, where the minimum punishment is 1 year, extended up to 5 years, your lordship. So these two sections are non-compoundable. So this case is pending before the presiding officer, District Council Court, Subordinate District Council Court, Sri D.S. Marbanyang, your lordship. And here, your lordship, like this both the party, like complainant as well as the accused, your lordship, they don't want to proceed with the case. That's why we have filed the joint petition, your lordship.
There is a compromise.
There is a compromise, your lordship, in page number 20.
How do you know that compromise is voluntary?
Because, your lordship, they came to us together, your lordship.
How do you know they have come together?
Because your lordship, here that there is nothing, one commotion took place, your lordship, for the sake of parking at Bada Bazar.
When this incident took place?
In 2015, your lordship.
2015, now almost 9 years.
9 years, your
When
lordship.
this matter was, it's charge sheeted, isn't it?
It was charge sheeted in 2015 itself, it was charge sheeted, your
And
lordship.
then till now, this has not been disposed of.
Because, your lordship, that the complainant here, she doesn't want to proceed with the case, your lordship.
Yes, prosecution 354 matters kept pending for 9 years, 10 years. This is how we are moving.
Complainant, she came, your lordship, for the evidence.
And then how do you see the compromise attained after 10 years? Is it genuine? How can it be genuine?
Because, your lordship, she came in the court also. The case was fixed for the evidence, your lordship. The complainant came in the court after receiving the summon, and she expressed that she doesn't want to continue with the
That should
case.
have been done the very first instance.
Yes, your lordship.
2015 a matter has been charge sheeted. After 10 years you come and say we have compromised. Almost after 10 years. 9
Yes,
years.
that
sounds very unusual.
because the lordship, they are working together there only. The complainant here is the fruit vendor, your lordship, selling the fruits on the roadside at Bada Bazar, and the accused, the petitioner number 1, he is a driving taxi, your lordship, from that same the Bada Bazar only, from Bada Bazar to Monga. So they are in cordial relations, your lordship. They don't have any it took commission took place only for the sake of parking, because that
They are in cordial relation, it resulted in filing FIR.
your lordship, there it was because of the parking of taxis, your lordship.
Yes.
Lordship, I'm being led by Learner A, Additional Advocate General, Lordship.
On behalf of the statement, I take notice. I get the instructions now.
Take instruction. This kind of matter, if
Yes.
it is settled, then what
Yes,
is the
sir.
use? What is the use of proceeding? You see,
We have to verify the settlement whether it's genuine or not, and then we get the instructions. How we do it.
issue notice, you take instruction. We'll just say.
Yes, we do it.
Yes, hard matter. Issue notice, returnable in 3 weeks. Mr.
Kumaresan,
DK Kumaresan,
E.K.
Along with
Kumaresan.
so and so, along with Mr. Harmanlam. APS4. Dearest phone number, APS4, the state
What
respondents. And hence no further notice is called for. The state shall obtain necessary instruction in the matter. This matter after 3 weeks.
High oblige.
Deeply obliged.
Deeply.
Daily costless. Item number 1.
Affidavit for respondent number 9 to 11 not yet filed.
Your Lordship, I pray if Your
Do you
Lordship.
really intend to file it?
Yes, Your Lordship, we have
What is your prayer today?
Your Lordship, kindly grant us 2
You take
weeks.
at a time, 6 months or 1 year at a time, and then
No, Lordship may give it a last chance, failing which the matter may proceed ex parte against the respondent 9, 10 and 11, Lordship.
last chance has no meaning, you see. We have seen this.
Because it's
Many
almost
matters,
2
last
years,
chance has been
Lordship.
given and then it's unnecessary.
Yes,
then
it's
again,
a
a
matter of
miscellaneous application is filed.
2022, Lordship.
You see, like if there is a real desire to file it, there should be filed. It is in
Yes.
your interest if you want to defend a case. Yes, say something.
Yes, Your Lordship.
Just say, Ms. K. Guru, learned counsel applying to the respondents. Praise for grant of further time for unavailing the respondent number 9 to 11 to file an affidavit, to file counter affidavit in the matter. Prayer allowed. List after 2 weeks. We'll just see next time. We'll just see if it is not
Yes,
there, then
Lordship.
maybe we have to pass, but then that also how much effective it is. Otherwise, this is this union's thing is there, affidavit is there.
Yes, union affidavit is
Then
there.
we can proceed on the basis of that.
A union, no, Lordship. It is of the institute. Ningrims
Whoever
is
it
there.
is, the establishment's affidavit is there.
Yes.
Then they are the main person, isn't it? They are the main respondent.
Yes, they are the main respondent.
Okay. See you.
Much more, Lordship.
Item number 2.
I pray that the matter may be taken after some time, Your Lordship. This is my senior conducting counsel under the courtroom.
Speaking about Mr. Devnath,
Yes, Mr.
he's in the
Devnath.
other court.
He's in the courtroom.
We'll have it after. Just call it at the end of the board.
Daily costless. Hearing item number 3.
Me, please, Your Lordship.
You have not filed an application.
No, Your Lordship.
Why?
Lordship, senior counsel has some submission, Lordship, to apprise before this honorable court, Your Lordship.
Tell us what his submission does.
Some instructions are with
This
him.
matter is simple. You say that somebody has died, then you fail to produce the death certificate.
Yes,
And thereafter, you are given a liberty to file an application for striking his name. So, what instruction is needed here? What submission is needed here? Matter is just simple, whether you have filed it or not.
No, Your Lordship. Some instruction are with Leonard Senior Counsel, Your Lordship.
You have to receive the instruction. Senior counsel will not have instruction. You have to pass the instruction to him.
Lordship, we kindly fix the matter at the bottom of the page, Lordship.
Huh?
We kindly fix the matter at the bottom of the page, Lordship.
There is already one matter at the bottom. This is a problem, you see. I do not know why, what is there.
Lordship,
The last many occasions you have taken time for production of death certificate. On the last occasion, so you say like it is, you could not obtain a death certificate. You are given the liberty to file an application, rather on your intention for striking of name. So that should have been filed. We'll keep it on record. Mentioned there in the date of death.
We couldn't
Nil pass order
ascertain the
according
date
to-
of expiry of petition and Your Lordship. However, like Lordship, we couldn't ascertain the date of expired of
So you do not know, only you know is expired. That also telephonically you cannot obtain. You can understand difficulty in sending this thing, death certificate. Of course, nowadays electronic media is there, so it comes very fast. You get it from one mobile to another mobile. We do not know what is going on. Anyway, call after sometimes. Let us see.
Item number 4.
Yes.
Your Lordship, the conducting counsel is in another room. Kindly let this matter come at the end of the board.
All the matters at the end of the board, not possible. This court cannot function like this. This court cannot function like this. If counsels appear, we'll take up. If not, then we'll just pass it. Are you the counsel here?
No, Lordship.
None appears for the petitioner.
There, he's here.
Yes.
Lordship, you're supposed to get some information from the department, my lord.
What information?
My lord, this is regarding the status of, my lord, because my prayer was that, my lord, the trade test ought to have been conducted on a different date, my lord. So, my lord, when the matter was before the Honorable Chief Justice, my lord, so he said that, okay, that same yardstick should apply for the petitioner as well. So, kindly you bring the record.
Yardstick means?
My lord, that to show that the interview.
Oh, you have to have instruction, isn't it?
Yes, my lord.
Have you it? Do you have it?
Your Lordship, the learned DHI will apprise the court regarding on that, Your Lordship. The learned DHI will apprise the court on pertaining to that instructions, Lordship.
So what is to be done this matter? The court should keep waiting for the counsels to come.
Your Lordship, if this matter may be taken up with... If not,
It appears that the rendered counsel for the respondent is not ready with the instruction when the matter was called out. At least after 2 weeks.
Item number 5.
All the matters are going like that. Yes. Yes, Mr.
My lord,
Doing it.
My lord, here the petitioner, my lord, he was working as a senior instructor in the Shillong Polytechnic since the year 1998, my lord. If my lord will come to Annex 1
of the writ petition.
Yes, my lord.
What is the relief you are praying here?
Now here, my lord, what has happened is he joined his service, my lord, since the year 1998, and thereafter, my lord, he applied for study leave in the year 2011, and then leave was granted, and thereafter he went for completing his MTech. After he completed his MTech, my lord, in the year petitioner joined back in the year 2011, and then 2009, my lord, he applied for study leave. He joined back in the year 2011. Thereafter, my lord, he was not promoted to the post of lecturer, because the service rule provides, if my lord will just kindly have a look at the service rule, page number 32.
This is a case basically claiming promotion.
Now, my lord, there are many things. Yes, initially it was a case of, there are many things, my lord. My lord, what has been...
What are those many things? Now you have to specify those many things.
Right, my lord. Page number 32.
Let us see your prayer. Just
yes.
We'll have to appreciate in proper perspective.
Right, my lord.
First, you have to see your prayer, and then
Yes.
we'll appreciate these materials.
Right. Page number 7, my lord of prayer.
It seems that you are praying for a disposal of a representation.
That is there, my lord, but what has happened is, my lord, they have not allowed me to continue with my service.
That is what
And they
appears
have
to
not
be. So,
released.
so far as your prayer is concerned, there is nothing. With
They have
regard
not
to
released my salary, so therefore, my lord, I have prayed that
you
my
want continuation and the payment of salary.
right, my lord. Now, if my lord will see page number 32 of my writ petition.
Page number 34.
32, my lord.
Yes.
Here, my lord will see the column schedule 2, the last column, my lord, down, lecturer, polytechnic.
Yes.
This is the post, my lord, where the petitioner was seeking for promotion. So from
This is the post seeking promotion. Now,
yes,
he is what post he is
he is the
holding?
senior instructor, my lord. Now, if my lord
one
will see
second,
the
just let us have it.
right, my lord.
You see, it says that 75% by direct recruitment, 25% by promotion.
Right.
Isn't it?
Right. Next column, my lord.
Now, then
qualification.
You see if you see third column,
right?
Person eligible for consideration for promotion.
Blank.
Now, this is blank here.
Yes. Next column, my lord.
Yes.
Experience and qualifications required. This column, last one.
First one is for direct recruitment.
Right.
And the second is
my lord will see experience and qualifications required.
Senior instructor in
appropriate engineering, and then remarks 10 years of satisfactory service in the own grade. Now, if a person is serving for the period of 10 years, he is qualified to be promoted as a lecturer.
Qualified to be considered
for promotion. My lord. Now, what has happened? The petitioner, because of this clause in the service rule, he has given many representation during the service. However,
when did you join? When did you join the service? As
since the year, my lord.
Senior instructor.
My lord, Annexure 1, my lord.
One second. 1 minute.
From
just a minute. Just
my lord. Page number 9, my lord.
One of you can go. One of you can go. Yes.
Here the date on which he joined, my lord, 10/7/1998. As a senior instructor, my lord.
He's a lecturer in electronics, isn't it?
My lord, what has happened? Even though he was joined as a senior instructor, he has joined as a senior instructor, but because there was no lecturer, so he performed the duty of a lecturer. He has been performing since that time only.
If you read this,
yes,
read it. Just say.
Is a lecturer in electronic engineering of this institute. He is serving in the same capacity with effect from he is an energetic.
Yes.
However, my lord, even though this says he is a lecturer,
if you want to say that this is a certificate, okay?
Right.
This is not an order of
right.
Okay.
Yes.
Mr. Singham, this court will have many queries. You have to
understand.
You see. Now the thing is that you have to show us some appointment order. Where is your appointment order?
My lord, the appointment order was not with him at that point. I could not file it because he must have misplaced that appointment letter. However, my lord, there is nowhere they have denied, and all the communications, my lord, of the government, it says he is a senior instructor.
Nowhere they have denied that you are appointed as
senior instructor only.
And then thereafter, just because of this thing.
Yes.
So you see, so far as the post of senior lecturer and lecturer is concerned, are they equivalent?
Here is the post.
See, what is your pay scale? You are getting a pay scale of lecturer or senior instructor?
No, my lord, senior instructor.
Now, what is the difference of pay scale between these two?
My lord, regarding the pay scale,
Is there any difference?
There will be difference, my lord. There will be
You
difference.
have to say it. See, you have to say definitely. See, because that is how you can establish that you were serving as senior instructor. Now, if there is no direct evidence to that by showing the appointment letter, then you have to find it out by different way, isn't it?
Right, my lord.
We'll come to the secondary materials. Now, this is how we'll do it. First, we'll ensure whether lecturer and the senior instructor belonging to the same category or not, same grade or not. Then we'll come to pay scale also,
Right, my
just to see. Now, then you have to satisfy this code, all those aspects. Before you establish, you see, like you have to establish your claim that you are serving as an instructor.
Yes.
So you have to refer to all those.
Right, my lord.
As you made a mention in the writ petition.
Regarding the pay scale.
Pay scale, that they are equivalent
No,
and
my
all
lord.
those
No,
things.
they are not equivalent, my lord, because that is the next higher post, lecturer.
So then?
So therefore, my lord, the
Then
service
can
rule says.
can a person from the post of lecturer be promoted to this thing?
No, my lord. He is not a lecturer. He is a senior instructor, but he was allowed to work as a lecturer because there was no lecturer at that point in time. He has been serving as a lecturer, even though he was appointed as a senior instructor.
You can understand that if you
Yes.
have done it, there must be some order, isn't it, to that effect?
There is no order, my lord, because this certificate itself is a proof that he was serving as a lecturer.
That is okay.
Yes.
Okay,
In
we can
spite
say
of the
we can
fact.
say in absence that is okay.
Right, my lord.
But then if you are a lecturer, then your petition becomes infructuous
I'm
because
not
you are
a
already
lecturer. I'm not a lecturer.
So your case has to be something like that. That in fact you are serving as lecturer, you're discharging duty as lecturer,
Right.
but then you are getting as a
Senior instructor.
sorry, you are getting salary of a senior.
That is my case, my lord.
So that is what your grievance.
Right, my lord. So now, what has happened, my lord? After I went for my study leave, and then I completed my MTech. Thereafter, my lord, I have joined my service in the year 2011. However, in spite of the fact that I have obtained the required qualifications, my service was never considered for promotion, my lord. In spite of the fact that I have given several representation before the authorities, my lord. And therefore, the petitioner put up a resignation letter. However, the resignation letter was never accepted by the government. In return, my lord, they have said that this cannot be accepted, and as per the FRSR, my lord, that clause was mentioned there, you have to return the study leave, whatever amount you have.
Please refer to all those relevant
Yes,
documents.
my
It will be easier for the
yes, my lord, may
Otherwise,
kindly.
it will just go like a story.
Right.
Yes.
Now, my
please
lord,
you refer to the documents which you will be referring, which
yes.
you will be relying upon.
Now, if my lord will come to the next annexure, that is annexure 2, page number 10.
Yes.
It says, as per direct, my lord, I'll just read the contents of the.
Your WL what is it? No. Joy?
No, my lord, that is the principle.
This is from so and so. Okay. Too.
Yes.
Okay.
Here it says, as per directed by the higher authority, I am enclosing herewith a letter received from the Directorate of Higher and Technical Education, which is related with your resignation. And as per government rule, you are to refund the actual amount of leave salary equivalent to pay and DA as per SR 100 of the Meghalaya FRSRs 1984 duly executed by you. Now, the next page is page number 11, my lord.
No, but then this is what? This is it with regard to what?
This has been given to the petitioner by the principal. After the
But then it is addressed to you.
yes. Now after principal
Now,
has received a letter.
See, in this letter, you are shown as senior instructor.
Right. I am the senior instructor.
So this is in 2013.
Yes, my lord. If my lord will come to the next page, page number 11.
Yes.
It says, this is a letter from Deputy Director of Higher and Technical Education to the principal. It says, with reference to the letter on the above cited subject, I am directed to say that as per SR 110 of the Meghalaya FRSRs 1984, a government servant who resigned from service within 3 years after returning from study leave shall have to refund the actual amount of leave salary, travelling allowance, if any, incurred by the government of Meghalaya with regard to the principal amounting to so and so, it shall bear the interest so and so. So ultimately what has happened, my lord, there were several communications, my lord, between the government and the principal.
Now tell us, when did you file your resignation letter? Where is your resignation letter?
My lord, my resignation letter, my lord, will get in the affidavit filed by the state, my lord.
You have not appended it?
No, my lord.
Now, when did you resign? What is the date of your resignation?
That is 27 November 2023, my lord. My lord,
No,
no, that is
Annexure
not
2
correct.
is
my lord.
not dated January, it is November.
No, my
isn't
lord,
it?
that is not correct, sir.
It is November, I think.
Where is that affidavit?
Okay, this Annexure 2 basically forwards the letter, forward the letter which is appended in Annexure 3.
Yes, yes,
Is it?
my lord.
Yes. This is what? Okay, then what happened?
My lord, he resigned from 1st November 2011. 1st November 2011. That is at page number 10 of the affidavit filed by the state, my lord.
1st November.
1st November 2011.
1/1/2011.
Yes.
1/11/2011.
1st November 2011.
1/11/2011.
Yes, my lord. That is at page number 10 of the affidavit.
Alright, it's alright. Just we'll take the note
My
and
lord.
then we'll subsequently come to the reply.
Yes, my lord. Now,
we were in Annexure 3.
Annexure 3, my lord, yes. So after this, my lord, if my lord will come to page number 12 onwards,
Yes.
these are several communications regarding his payment of refund.
Same thing.
Same, my lord.
Now,
Till 14.
Though you resigned in 2011,
Yes.
they initiated this recovery process only in 2013.
Right, my lord.
There is no time limit for doing that. No.
I'm not aware, my lord, whether there is any
Now,
time limit.
Whether your resignation was accepted.
Never, my lord.
Now, if it is not accepted, did you withdraw it?
No. No, yes, I have withdrawn, my lord. And thereafter, I was allowed to continue with my service.
You have withdrawn when? Which date?
That is there, my lord. Here, page number 6, page number 16, Annexure 6. Here I have prayed to, I have allowed me to continue, they have allowed me to continue in my service because of these applications, my lord. I have.
Annexure 6 is.
Annexure 6,
This is your application.
page number 16, yes, my lord. And thereafter, my lord.
Wait. Let us just go. Why you are so far?
Sorry, my lord.
We just at least we should get the picture.
Right.
You know your case better. This court doesn't know.
Right, my lord.
Now, by this letter, you have claimed the post of lecturer.
I wanted.
See, what you said, that you allow me to come back to service.
Yes.
The post of
lecturer.
Now, that is what probably were.
I wanted.
And then what happened?
They have allowed me to continue in my service in the post of senior instructor, where I was serving. Next page, my lord.
Then you again accepted that one.
Yes, I have filed my.
No, this has become a mess then in such a case. Where is the letter they
entire
by
case
which
is
they
a
have
mess,
allowed
my
you?
lord.
What is the order by which they have allowed you?
This next page, my lord.
Who are the authority? Is it the state or the college authority?
State has allowed me, my lord.
No, government polytechnic is a government college. Definitely, any authority would mean say authority of the state.
Yes.
Now, if somebody is appointed, it is not by the, it is not the college which appoints.
Right.
The government appoints and then they post them to college.
Right,
Isn't it?
Yes.
Now, this is a letter. If at all it is accepted, there has to be an acceptance.
Right.
Or rejected, there has to be rejection.
Rejection.
It is not there. And then without any any official or written order, verbally you were allowed to again
Not
rescind
verbally,
the,
my lord, by writing.
where
It's
is
there,
that?
page
Where
number
is that?
17, my lord.
Okay. Okay. So resignation chapter is over by page 17.
Yes, page number 17, my lord.
Now you accepted that.
Yes.
Now one thing is that you have seen this letter says that in case you rejoin, you will have to update and regularize your period of absence of nearly 4 years.
Yes. Yes, my lord. So thereafter I have
Which manner you do it?
now after I have resigned my service, my lord, that is page number 18.
Now what is meant by that? That means the updatation and regularization of period of absence. How it is regularized?
My lord, this has to be done by the government only.
So definitely how it was regularized?
Nothing, my lord. There was no communication in this regard as well.
So here that was not regularized. You see, it is your urge to get it.
It was the duty of the government,
Otherwise,
my lord.
4 years
Right.
absence.
No, my lord. That was study leave. I was on study leave, my lord. Sanctioned study leave.
This letter says absence.
No, but that is because 2011, my lord, I have.
Anyway, chalo, let us go ahead.
Thereafter, my lord, page number 18 is my.
What is this date?
This is another request, my lord, to place me as a lecturer.
What is the date of this letter?
Which letter, my lord?
The date, Annexure 8.
Annexure 8 is page number 18.
No, what is the date of on which date you have written? Down below there is acknowledgement when
There
it was
is,
received.
yes, my lord, 24th November
24th November 2015.
Could be this date only, my lord.
So that means after joining, after resumption, you again pray.
Again prayed for putting me in the post of lecturer, my lord.
No, these are all confusing kind of letters. You want to get something emotionally.
Right. Letter.
The expression of emotion in the letter.
My lord.
You see, the problem is that what you write and what you do are quite different. If you really wanted that you should be given post of lecturer and in absence of that you will not continue work, you should not have rejoined. You've rejoined. This letter specifically says that you have rejoined as senior instructor.
Yes. Because I was allowed to resign as senior
instructor. And then again you
write a letter, my lord, to promote me to the post of lecturer. Because he has done it because the service rule, my lord, it provides so.
We can understand, but then in such a case, your claim should have been legal claim.
Right.
It should not be something like that. You see, like you do, you'll give up the job. You are not giving promotion. I will leave.
Ultimately, my lord,
you
what
leave,
it seems.
Then after a few days, again you come back. You join to the post.
It's all because of his frustration, my lord. Because he was not, because he worked for so many years, but still his promotion was not considered.
Then what happens?
My lord, that next page is his joining report, my lord, page number 19.
2016.
Yes.
We see these letters are of 2015. Then rejoining is Letter is of November. Then you write a letter 24th November. Then you join in 2016.
Yes.
Now you say I'm joining back to the office. That means you are joining back to the post of same post on 8 January 2016.
Senior instructor, my lord.
Yes.
The
You
next
have signed it here also as a senior instructor.
senior instructor, my lord.
Yes.
The next page, my lord, page number 20,
Yes.
is my last representation, my lord, that was filed by me
Yes.
to consider again as in the post of lecturer, my lord, to consider me for promotion. This is the last representation that this.
Kindly see the first line. First paragraph.
Yes, is contradicting.
Have you seen? See the joining, he's joining. Number 1, para 1.
Yes, I have seen, my lord. It is because, my lord, he used to serve as a lecturer, but his appointment is of senior instructor.
You have a copy of appointment letter, his appointment letter? Initial appointment?
It's not enclosed, my lord. They should bring it on.
It is not enclosed with our affidavit.
No, with your affidavit. What is your case here?
Lord,
Mr. Sinkan, in short, is that you have given service in the post of senior instructor for 10 years,
10 years.
and you are entitled for promotion, so they should consider you for promotion.
Right,
That is your
my lord.
case.
That is my case.
Sum and substance.
Right.
Of course, we will be coming back to you for details things.
More than 10 years.
Just want to get a glimpse of what reply they have given.
Right.
What is your defense?
My lord, firstly, my lord, the petitioner was serving in the post of the, my lord, senior instructor in the electronics department of the Polytechnic.
How you was taken
Now, my
into
lord,
service?
my lord,
Through advertisement. Oh.
my lord, of course.
Yes. Let him say, because you see, like you yourself claim here that you are a regulation 3 appointee. There seems to be confusion.
Right.
My lord, of course, that we have not stated in our affidavit.
Then
my lord.
how this court will decide this matter?
My lord. So that then, my lord.
What is it? Just tell us.
No,
in a
my lord,
nutshell-
our case is that,
tell
my
us
lord.
in a nutshell, what is your
Yes, my lord.
defense?
So what had happened, my lord, in the year 2009, my lord, he applied for a study leave. Study leave?
First come from appointment.
My lord.
How he was appointed to which post?
My lord, he was appointed as a
Let us come to your affidavit.
yes, my lord.
Very interesting. Illegality and illegality.
As a senior
Even
instructor.
Forget about the petitioner. What government does, this is very realistic. Let us see how you have taken him to service.
My lord.
Was he an appointee under Regulation 3F?
My lord,
He
I'll
claims
have
in
to
his
admit,
petition.
my lord,
Have
none
you
of
seen-
these
Have you
things.
seen that representation?
My lord.
Which just now we have taken note.
Yes, my lord.
The first paragraph he says that he was a Regulation 3F appointee and serving in lecturer post. Is it correct?
No, it is not correct.
So he was not a Regulation 3F appointee.
My lord.
So he is a regular appointee to the post of senior instructor. And if he, then how he was taken to service? Just tell us the details.
My lord, of course, I have to admit that fact, my lord. That fact is
You
not
know,
on.
Of course, this is not
on
your
record.
case. This is petitioner duty. He has to tell us how he has been taken into service. But in Indian government,
My lord, that fact is not on
it-
record, my lord.
but somebody is taken into service. Government is paying him.
Yes, my lord. I
There
admit
must be
that.
record how he has come
Exactly,
into
my lord.
service.
Now, what I am telling, my lord, is that in the affidavit, of course, I have not enclosed, my lord. So, my lord, if kindly grants me time, my lord, as far as the appointment of the petitioner is concerned.
So, see, there is no question of granting time until let us see in his writ petition what he says.
Because even in the writ petition, he has not enclosed his appointment letter.
No, then we will say that he doesn't have a valid appointment.
My lord.
My lord, no other
Correct.
option. Because his claim himself is contradictory.
My
He
lord,
says
may
that-
kindly see all the other NHS, my lord, which I have enclosed. It clearly says I am
See,
in government.
just because-
I am a government servant, my lord, and plus.
maybe
And my lord,
but
another
then
aspect.
What is the
And I came through an advertisement, my lord. Post was advertised.
What is that advertisement?
Neither the
My lord,
advertisement
it's
is
been
enclosed nor
in
the appointment.
Prior to, my lord, it's been long time, so he has misplaced all these documents, my lord. So let the government.
No, if you have a misplaced, have you applied for a copy? Getting copy is not a problem nowadays. This cannot be an excuse. You see, at least if you are claiming relief before a court, first you have to show you have a regular status.
That is,
you are working in a permanent capacity, then we will decide.
yes, my lord.
You see, at least one thing is that, okay, you have served in the department for 10 years, and if at all you are serving in a substantive post, then definitely you should be considered for promotion. But the only thing is that your own application says that you are regulation 3 appointed.
No, my lord, I have never mentioned regulation 3F, my lord. Nowhere.
That is what this court was referring to. See, your representation come.
My lord, in the representation, but in my
No, that is the
petition I have not.
In this representation, you have appended with the writ petition.
Yes.
So, which way? It is not that you are an uneducated person. I have joined into government service as a lecturer. So this is the initial thing. That is enough. That is enough to reject your case. You will go by this.
No, my lord, here he has been working as a lecturer, even though he has joined his service as a senior instructor.
Can you give an argument which is not supported by your own writing in the letter?
No, my lord, may kindly see page number 9 of the annexure 1. It clearly says he has served as a lecturer, my lord.
Now, if you that is what he has served as a lecturer, but then he is under regulation 3 as a lecturer. That is enough, good enough. Regulation 3F, how long you can continue?
My lord, as far as appointment is concerned, let the state government bring it on record, my lord.
Why shall we burden them? This is your case. You have to stand your own feet.
My lord, the documents are not with us as on today, and ultimately it has to be given by the government only, my lord.
You say that you have been appointed by virtue of advertisement. That is also not with you. Let us see what you have stated in your writ petition.
My lord, in my writ petition, I said I've been working as a lecturer in the electronics engineering at Shillong Polytechnic.
Okay. Then your entire submission goes.
In spite of the fact that he has joined as a senior instructor.
So your submission contradicts that thing.
No, my lord, I have specifically mentioned he has joined service as a senior instructor.
He has been working as a lecturer in the Now see
paragraph 2, my lord.
How we will interpret paragraph 2 and 3? Just see.
Here it says, my lord, that the petitioner states that he has been working as a lecturer in electronics engineering at Shillong Polytechnic with effect from so and so date. In spite of the fact.
Come to the next paragraph. Come to page 3.
Petitioner applied for promotion in the year 2004 to the post of
He is
lecturer.
working in the post of lecturer. He applies for a post of this thing.
Yes. Now, my lord, paragraph.
How you will explain this?
Paragraph 2.
Yes.
It has got two parts, my lord. It says he has been working as a lecturer in electronics engineering at Shillong Polytechnic with effect from 10/7/1998 in spite of the fact of joining the service by him as a senior instructor, but due to lack of lecturer in the college has worked as a lecturer, my lord.
So how do you say it? On what basis you are saying?
I was saying this on the basis of annexure 1.
If you say in spite of the fact that you are this thing, then must be materials on record. It is not something that you do of
on the basis of annexure 1, my lord. It says I have worked as a lecturer, my lord.
Doesn't say about anything about senior.
Whereas all the government officials record, it shows me as a senior instructor because I was appointed as a senior instructor.
But then again here it presents says that you are lecturer.
It says I am working as a lecturer.
Supposing as a rule of prudence, if there are contradictory statement on your part, which will be accepted?
My lord, may kindly see
Any contradiction
in my entire petition, all the representation I have enclosed. I am claiming for promotion to the post of lecturer. Why I am praying, my lord? Because the service rule provides so, and I have been working as a lecturer in spite of the fact that I am appointed as a senior instructor.
So see one thing, Mr. Sinkan, you must appreciate that you will be eligible for promotion when you are in a regular service, isn't it?
Right.
Just by an appointee under regulation 3F, you cannot expect promotion.
Now,
if you yourself you say that I have been taken into service under regulation 3F as a lecturer, then what remains to be decided?
Now, it may be that, my lord, his service has already been regularized, my lord. Otherwise,
We cannot go.
other questions will not come
you
into.
cannot say by, see, one thing, please
Yes.
appreciate, you are standing here. You cannot adopt the sentence that way, that it may be and may not be. You say it must be. That is
Yes.
how you prove.
No,
the case
because
before
it must be. Otherwise, my lord, this
So,
government communications.
If you say must be, then you have to, you see, make it clear
Yes.
that you come to service as a senior instructor.
Yes, my lord.
There is a letter to that effect. And then, because of shortage of the number of lecturer,
Yes.
you are entrusted with the work of lecturer.
Lecturer, my lord.
Now, these two should be very much clear.
Right.
You refer to a certificate which says yes, you are functioning as
a lecturer.
Lecturer.
Yes, my lord.
Okay. Now, if you see there, it says from 1998. Your certificate?
1998.
Yes, 1992 you are lecturer. Now, this certificate coupled with your statement in that representation, it says that you have been taken in service in 1998 under Regulation 3 as a lecturer. Finish. Gone. What remains? There is nothing on record to show that you are serving as senior instructor.
My lord, entire record says, my lord, I am serving as a senior instructor, because all the communications, my lord,
So far as your retaking into service is concerned.
communications of the government, my lord, it says that I am the senior instructor, my lord. They have nowhere denied.
You procured those
My
necessary
lord,
documents.
in
given
para
us.
2 of the same representation, my lord, what the petitioner says, my lord. That, sir, I lost the post of lecturer when MPSC conducted an interview for regulation and had to succumb to the level of post of senior instructor.
Is it?
With effect from October 1999
That
till
is
date.
once that post was advertised.
My lord, the petitioner will have to have requisite qualification, my lord.
My lord, he has the qualifications.
Just a minute. Okay, you failed in this thing. Try to qualify. And what do you mean by succumb to the level of post of senior instructor?
My lord, I also require some instructions whether he participated during this process of selections, because
see, that is definitely once
yes.
that is one thing. There will be clear. If you fail to qualify,
no,
then definitely
whether I have participated.
That's what. Okay, we'll come. We'll give you time.
My lord,
don't get agitated. This court will not give you easy passage.
Right.
You have to come across many hurdles to satisfy this court. See.
Right.
Now the thing is that what requires to be determined is that you have a legitimate claim over the post of
senior instructor.
And once you establish it, and once you show continuous therein,
yes,
continuance therein for 10 years, definitely as per the rule which you have referred just now,
right,
as per the schedule should be, you have a right to be considered for promotion.
Considered.
Now, as this court has already told you, in absence of this so many contradictory statement, now at least you have to say that under what pay scale you are getting salary, all those things right from the inception. Now there is nothing in your thing.
My lord,
in which way we will establish. We can understand government may have the record, but this is your case.
Right.
Burden of proof is on you. Until and unless you prima facie satisfy the case, prima facie satisfy the court about the case, you see, like, then we cannot ask the government, cannot settle that responsibility with them.
Yes, my lord, I'll require some instruction. Let the matter come up after 2 weeks. And in the meantime, my lord, if the government
so please take the instruction. You see, it not means that you say you know what is your stand in the thing affidavit. What is your stand in the affidavit?
My lord, firstly, my lord,
if something is admitted, then why should we?
My lord, in response to para 2, we have stated in our affidavit, my lord.
Yes.
That the answering respondent
Where is your thing? Where is
my lord, our affidavit is, my lord, dated 23/5/2018, my lord. Page 2, my lord, para 7.
By everyone before response number 1, 2, and 3.
My lord, yes, my lord, 1, 2, and 3.
And then you are referring to
my
page
lord,
2.
Page 2, para 7. This is in reply to para 2 of the writ petition, my lord.
Served as a senior instructor in Polytechnic.
And not as a lecturer.
Not as a lecturer. Now from when to when? Under what capacity?
My lord,
Is it in a substantial capacity? Is it a temporary
my lord,
appointment?
I am afraid, my lord, that is not reflected.
So this is cryptic type of reply. The cryptic statement in writ petition.
It is not detailed, my lord. That I admit, my lord.
Your admission is not helping us. Why don't you understand? We have to decide the matter.
Yes, my lord.
So
my lord, by next date, I will also, my lord, find out the necessary things.
it's a taking blame or admitting,
No, Lord.
mistake would not help us in deciding. Kindly understand that.
Yes, my lord. I understand, my lord. My apologies. My lord, what our case is that, my lord, apart from that, petitioner had gone for a study leave, my lord, saying that from 2009 to 2011, my lord, saying that he will complete the course of MTech, which he never completed, my lord. My lord, there is, let the petitioner show any certificate, my lord.
My lord, I
He
have
has never
enforced-
produced any certificate to the institute, my lord. Now, as far as subsequently tendered his resignation, my lord, as far as resignation is concerned, my lord, it could not be processed only for the want of, because he is not ready to settle the claims. That is the only reason that it could not be, resignation could not be accepted.
Now, what happens in such a case? Somebody doesn't come forward for settlement of claim.
My lord.
Do you allow him to take back in service again?
No, he cannot, my lord.
You've done it. You've done it here.
Yes.
My lord,
How do you explain that action?
my lord, the petitioner had approached his honorable court. Only thereafter, my lord.
No, my lord, that is wrong. Prior to that, my lord, he was allowed. It is part of my writ petition itself.
No, even if it is after he approached this court, was there any direction from the court to do that?
Yes, my lord. Not to interfere with his service.
There was a direction, to which, of course, we also filed a miscase, my lord, against that order.
Not to interfere with his service.
Yes.
Now,
Against that, we also filed a
service
miscase,
in
my
which
lord.
post?
Senior instructor.
As a senior instructor, my lord.
Where is that order, interim order?
Order is there.
Where is that?
Court order is in this affidavit only itself, my lord. Page number 29.
Interim order passed?
Passed by the single judge, my lord.
Against which we also,
same case? The same case?
In this case only.
we
my lord.
immediately filed
No, how can that be in your writ petition then?
No, that is in their affidavit, my lord.
In their affidavit?
Yes.
What is the page number?
Page number 29.
Thing becomes very difficult.
Yes.
Page 29.
Last paragraph.
Just a minute. There are Annexure 3.
Annexure 3. And my lord, against that, we immediately filed a miscase also for vacation of this order, my lord.
Never vacated.
There was a contempt also filed, my lord, which was dropped by this
Just
honorable.
hold on. No, it doesn't say not to disturb the service of petitioner where he is posted at present. Doesn't say which post.
Senior instructor, because he
How do you know?
the court knows that time, because he from record it shows he was working as a senior instructor.
So then
He served as a senior instructor.
where is that document? You point it out to us that
Now, if my lord will come to the same affidavit, my lord, just to clarify on this point, page number 15, same affidavit, my lord.
This is pagination, two pagination by the same color ink, it becomes very difficult.
Page number 15, my lord.
This is a 16 March 2012 letter dated?
Yes.
Yes.
It says, with reference to the letter on the above cited subject, I am directed to say that resignation of Sri J.S. Rinja, senior instructor in electronics engineering, Shillong Polytechnic, cannot be accepted due to the following conditions.
We've stated that, my lord.
Yes.
That is all right.
So it says he's a senior instructor, my lord.
My
From
lord,
the
what are
record.
the criteria, my lord? FR 95 2B.
Very interesting. One way government issues a certificate showing that you are functioning as lecturer. In the same way they say they are
Senior
instructor. Which one is correct?
Because he was working as a lecturer in spite of the fact that his joining is as a senior
My lord,
instructor.
this certificate is issued by the principal. Of course, I admit that position, my lord. But, my lord, this is a mere
Principal is the
certificate.
authority under you, isn't
But
it?
this is a
Is it
mere
your case
certificate,
that
my
he
lord.
doesn't have the authority? Have you
My lord, the appointment will have to come. My lord, if there is any appointment order,
See,
my lord, it has to come from the government, my
You do
lord.
not know what your officers are doing. You do not know which way your officers to be regulated. And even something wrong is done, you never make them answerable. And this kind of things happen. And then ultimately you will end up in court. And you do not know where you are. neither here nor there. Now,
Lord,
there is a
yes,
responsibility on the part
admit
of the
that, my
court
lord. Yes,
to decide a matter correctly
yes,
to the best of its understanding.
that I admit.
Now you see, like the points which are required for doing that, these are missing.
Yes.
Which we decide. It is not disclosed in the writ petition, not in your
Affidavit. That is correct.
These are all evasive statement. I am in service. I am in what service I do not know. I am lecturer also. I am in senior technical assistant also. There is nothing on record by either of the parties to bring on record his appointment, origin appointment, by which he has been taken into service. Where is that? And why you have failed to produce it if he has not done it?
Yes, my lord. My apologies.
Again, you are coming to same thing. Your apology will not solve the problem.
Yes, my lord. So, my lord, if my lord kindly grants time, my lord, I will try to rectify whatever mistake is there. My lord, we will try to rectify, my lord, as far as the government is concerned.
Mr. Singh, can you take instruction about
After
that thing,
2
whether
weeks,
you have taken part in the MPC selection
My
or
lord.
not?
Let it come after 2 weeks.
He has not taken part. He could not have, my lord, because he does not have the requisite qualification.
It appears that some more information with regard to the claim of the petitioner to the post of lecturer in the Shillong Polytechnic.
Yes, ma'am.
Shillong Polytechnic.
You said it appears that is required to be placed before this court for proper adjudication of the matter. The landed councils appear by the parties seeks grant of some time in order to obtain necessary instruction with regard to the original entry of the petitioner. Let alert least after 2 weeks.
My lord, may I pray, my lord, if the matter is taken up after 3 weeks, my lord, in the meantime, I will also get instructions, my lord, and my humble prayer, my lord, if we are allowed to file an additional affidavit, my lord, subject to the instructions.
That will depend upon your thing. Why should this is nothing. Just make it the files thick. We have
No, my lord, so that so that everything is clear, my
we will
lord.
not do until and unless that is required. You see, we will not tell you to file anything. If there is any official order, we can take cognizance.
My lord.
It is permissible under Evidence Act. Presumption of genuinity of the government, of the documents of the government. If that comes to that extent, but then we need the definite information with regard to his original entry into service and in what capacity and what was the mode and manner of this.
My lord.
Now he himself says that he was appointed under advertisement and taken into service. Again, his representation says that he is a Regulation 3 This is a total contradiction. But then only thing you see, like that, this court wants to determine the correct thing, so that is why. Otherwise, maybe you could have taken that statement and decided the matter here. But then that may not do substantial justice.
Second call, item number 3.
My lordship, maybe the other side is outside.
None appears for the petitioner. MS so-and-so is present. Yes.
Lordship, I have received instruction, Lordship. We have been able to get the contact details of the client, Lordship. So, Lordship, I'm praying for 2 weeks to
You have
bring on
received the instruction. You see, the last order says you are supposed to file a petition for striking of the name.
Lordship. So, Lordship, the difficulty is that we could not get the contact details of the petition number 1, Lordship. So somehow, Lordship, we have been able
Then
to.
you say that you have received the instruction.
Lordship,
So without contact detail, how will you receive the instruction?
Lordship, that was like in respect of her that Lordship.
See, if you have a definite set of instruction, you place it before the court. You cannot cover up. You see, if you say one wrong thing, then many other questions will.
Lordship, so I quite follow, Lordship. Now, Lordship, we have been able to get communication from the client, Lordship. So he will be sending us the documents from Garwell's, Lordship. So last opportunity, maybe in Lordship to please on record it.
Counsel for the petitioners, please for grant of some more time for filing a petition for striking of the name of the petitioner number 1. The counsel appearing for the respondents have no objection. List of topics. You do it. See, will not get, this court will not give any.
Lordship, we'll ensure that we have highly obliged.
Supplementary cost list, item number 2.
Yes.
Lordship, in this case, in this matter, Lordship, as per the, it was taken up on day before yesterday.
Yes, matter.
Lordship, as per the instruction, Lordship, with regard to the qualification of the teachers, the NCTE norms is being followed, Lordship. But with regard to the appointment of the teachers, Lordship, there is no laid down norms. Only, Lordship, at the time of upgrading the school under SSA, Lordship, certain instructions and directions are issued in the order regarding constitution of managing committee, appointment of 3 teachers, and then forwarding of the name of the teachers.
No, the thing is that you approve all the appointment, isn't it? All the appointment which are made under the scheme, you approve it, isn't it?
Lordship, the approval, as a matter of fact, in under SSS school, the approval is by way of signing of a contract agreement, Lordship. There is no separate approval order.
Where is the contract agreement in respect of the petitioners and the respondent number 7?
It's there. He's for the managing committee.
Do not ask. You said that is a contractual thing.
Yes, Lordship.
Where are those contract papers? We want to see it. What is the essential conditions stipulated therein?
Contractual agreement is signed between the teacher concerned, the managing committee, and
what are the contents of those contract?
It's not there, Lordship. In this present revision, it's not there. It is not there.
You said that this is a norm.
Yes.
Under the SSS scheme.
SSS scheme.
That approval of appointment means execution of an agreement.
Agreement. Yes, Lordship.
Okay.
Yes.
Now, what are the stipulations made in this agreement? That is the question. Just tell us.
Lordship, stipulations. I have to get one sample agreement, Lordship. Because right now I don't have it.
Done it. You see, we must know the controversy is this. Yes, Mr. Devnath. Your original entry.
Your Lordship, after this debut yesterday, then I was trying to contact this managing committee, and they are not in a position to give any sort. But after this, Your Lordship, I have gone through. Your Lordship, I've gone through these matters, how matters coming up, and how this appointment made. And I have collected some information about it, and then I have collected the documents regarding events for how this
as per instruction, Lordship, that is how it is done.
Just
appointment.
Just I have collected this resolution how this respondent number 7 was appointed. Originally, and what is the appointment letter I got. And
this is resolution. What is the appointment letter?
Yes. Appointment letter and the joining. I got it, Your Lordship, now. So I have just this handwriting, so I have to what is type, Your Lordship. And moreover, Your Lordship, I have studied and the matters because we are saying the NCT norms to be applicable to the teacher. So this is the matters, Your Lordship, big issue here.
Now, what happens is, supposing at this stage, if it is detected after so many years of service,
no, Your Lordship,
just a minute. The court is putting you a question. Okay, you are found that you are ineligible. Then what happens? We do not give any relief to the writ petition.
This true.
Because admittedly he doesn't have the qualification.
Your Lordship. So in this respect matters.
And then what happens to you after so many years of this thing? Can it be legitimized? Can it be legalized?
Definitely not, Your Lordship.
So then you also will go, your service also will
so Your Lordship, here in this case, now controversy is there between the petitioner and the respondents as a whole, including the government. That's we have challenged this his appointment is not correct. This is the ultimate here we are before this honorable court. So you will see here, when this managing committee has decided to form the school, and after the 2003,
When this school was formed?
In 2002.
2002.
And after 2003, government is given the approval. And when this inspector is given in 2002 itself, so I'm having this
All the
my-
information.
and the information. So what's happened was subsequently in 2010, the right to education act has come up. How this right to education has come up, then also it will be, I think, better to disclose here. And I have having the notification RTA Act, and the rule, and rule framed by the government of Meghalaya, and subsequent relaxation given. So all this notification I am having in receipt, but it is I have got it printed. Printing is not to the extent, but I got. So here you should just just a bit. If I give the compilation, it will be better because I've got all these methods in compilation I made.
Okay, you make a compilation, but then we'll keep this matter part out.
No, part out is definitely will be there. So you should just I'm just simply saying in 2012, you see, government of Meghalaya they have passed it to the central government for relaxation of the rule. And
Could not follow.
government of Meghalaya has requested the central government for relaxation of rule for the appointment of the teacher and qualification. And this also be approved.
2012.
2012.
No, but then this relaxation will definitely not have retrospective effect, isn't it? It will have prospective effect.
Prospective. And moreover in this given.
So that means that will not give you any advantage.
No,
because you are 2002.
No, you listen.
It will not give advantage to
No,
him.
This too you listen. But here you listen, and this here you listen. Even in this situation given, if had it been given, even that they are not having the requisite qualification, and then given the 5 years time to complete the qualification.
To acquire the qualification.
Acquire the qualification. This also in this notification, and on this notification given.
So that is okay. 5 years from which date?
From the date of 2010.
So 2010 or from the date of entry.
Yes. So you will see.
No, just say that is what you have to clarify. Do not say yes here also, yes there also. If both comes as positive result, then court will not be able to.
No, this from
You come to
2010.
service, the contention, basic contention.
From the
After-
date
you
of
see-
notification, you will see.
You see, this qualification part arose from the resolution of the managing committee, which was accepted by the government for terminating his service. Now, entire argument, though it started in a different way, but then it came back to the promotion, the only point got stuck there. And then it is admitted. The petitioner failed, he said yes, he doesn't have qualification, but then at the same time contents, you also do not have a qualification, and then you could not have been replaced. Him could not have replaced. Had it been a case of replacement by a properly or say like a eligible person, qualified person, then it would have been a different thing. Now, in view of this contention, now what requires upon you is to establish that you had the requisite qualification to claim a post in his place. Probably, if a question may come that he doesn't have qualification, he should not have a law standard to challenge. But then the fact remains that he was holding that post for some time, rightly or wrong. And his ouster is because of your entry. So that way definitely he will have. You see, otherwise you could have rejected his petition saying that he doesn't have law standard, you do not have a qualification, what right do you have to challenge? Okay, but then it is not that.
And in 2012 it is given.
So here what is needed is that if at all you say that there is a notification by which you are allowed to acquire the deficient part of your qualification, okay, then where is the period prescribed for you? From 2002 by 2007 you should have cleared it. Was it done?
No, this is after this RTA Act come into force, not prior to this.
So your service is prior to it.
Prior to this.
We are see, you have contended that other day by placing reliance on that notification that the qualification prescribed in 2010 notification will not apply to you.
Yes.
Isn't it? That was your case.
Yes.
Now the senior counsel basically has replied to it, saying that okay, 2010 qualification may not apply, but then you must have qualification which was prescribed in 2001.
Yes.
To get benefit of that 2010 notification. to escape from that part. So now it becomes on your part to establish that.
So, Your Lordship, in this respect, madam, my this submission will be here.
Second thing is that another thing, just apply in your mind is that you have replaced him in 2017. Now, if you are considered as a replaced candidate, then as on 2017, you must fulfill the requirement of 2010 notification. Mr. Devnath, there are many things to be ascertained here. This court also till now has not decided, because considering that you are in a service for quite long time, and any adverse pass will have serious consequences. Mr. Sangresho is already out of service. Maybe he is coping up with his situation, but then you will be nowhere. Take care of these things. You should not have a. And then the state, though, which way it functions, nobody can.
The question is whether respondent number 7 he possessed the qualification or not, either in the 2001 notification or under the 2010 notification. If not, Lordship, it will amount to replacing one unqualified teacher by another unqualified teacher.
Now you are supporting whose case? Just tell us. What is your stand? Are you supporting the petitioner or the respondent number 7?
No, for us we have to follow the norms, Lordship.
Then how could you approve appointment of these two persons?
No, Lordship, because here this joint.
You say that we'll take that submission to very record. We'll appreciate it. But then just give us one example where you have followed law.
Lordship. But that is how the appointment is done, Lordship.
See, you do not do. You commit illegality. You encourage the wrongdoing by the parties. And when you are in problem in the courtroom, you come and say that we are with law.
Lordship,
not a very correct approach. We can understand that your duty as a counsel.
Lordship, as per the practice, Lordship, some instructions are there, government instructions.
So if this court quashes the appointment of the respondent number 7 also, rejecting claim also, petitioner state will have no problem, isn't it?
Lordship, because this SDSU and joint DMC.
Is it your case that state is not defending anyone here?
Yeah, Lordship, we are not taking side anybody.
So you will not defend your own order also.
No, Lordship, the case is like
which
this.
You have appointed.
No, I'll point out to your Lordship. It's like this, Lordship. The SDSU and the joint DMC, they are not the authorized officers to give the approval.
Then
here I don't know. It's the mistake
Then
of that.
Who are the authorized officer to give approval?
Here, as per the instructions, Lordship, the approval is given by way of
instruction.
Your Lordship, I have received the PDF documents. Lordship, I'll place it on the next day.
You take a printout to place it. Mr. Sangresho, we'll keep it part hard.
Yes.
We'll keep it part hard.
Yes.
Let them give a compilation of
Yes, yes. In next week,
it may not be a part of writ petition. If it is not a part of writ petition, probably all the documents we cannot take into consideration. But then, so far as the government notification, and there will not be a bar for this court to take cognizance.
Yes. Regarding law points.
Because this court basically is trying to give a justified one.
Right.
Lordship, as per my instruction, Lordship, the approval is by way of signing of contract agreement.
That is what you just.
I'll place those PDF
Let them
documents.
compile it and let them come up on Wednesday or Thursday.
I'll come up on the next
for final
day.
hearing.
We'll give them 1 week time. Let them type it and then we will come up.
Second.
1 week will be enough for you.
1 week will do. We'll just bring
Mr.
on the
Devnath,
court.
and 1 week will be.
1 week will 1 week.
Please do not delay it. We'll keep this matter part.
Yes.
Okay, Mr.
We are not taking sight of anybody, Lordship. We are just placing the correct position.
That is basically the government should be
At the
role
district
model so far
level,
as
mostly
this
the
is
officers,
concerned.
they just give the approval without.
Mr. Kharmi, you
Yes,
are making this submission. We appreciate that.
Yes,
but then see your action.
Your
Which
Lordship.
you justify all those.
Your Lordship, because this education matter, this is the first time in this come up. So if learned friend is saying that there is an agreement, and when I discussed with the managing bit, I didn't get anything. So if we have any this matters of agreement,
Let the documents come in. We'll just see what difficulty arises. Right now, we cannot presume what situation will arise. Right.
I'll place all the positions, Lordship.
And then probably the agreement which you executed, if you remained with that, this matter would not have reached that stage. So you can think about that also, going back to that position.
I'll place
so
all
that
the
both of you remain secure.
documents.
Okay. Think about the security. Okay. If it is possible that you remain secured and petitioner also gets the position which is claiming, then matter is over. think that way possibly that can be done. Up to you. This court is not telling you anything.
Right.
But then once, as has been pointed out by the senior counsel yesterday, that we studied, he pointed out to some agreement, basing on which earlier round of writ petition was withdrawn. And for certain period of time, he got his salary. Thing was going on. But then again, he took a somersault, he changed. So now, see, you have, that is testing, now problem is coming back to you also. You raised the question of qualification, this is your managing committee, you took a decision, now it has backfired. Now you are answerable for the qualification. Now contention has been raised that, okay, I am not qualified, but then how you, another, you see, like, person who doesn't have the qualification comes and replaces. Okay, you just say, the, wait, let us pass the order. Mr. H.R. Kami and Mr. R. Devnath, Lorded Counsels for Mr. H.R.
I'm for respondent 1 to 4.
Mr. R. Devnath, Lorded Counsel for Sojan sir. Praise for allowing them some time. Praise for granting them some time to enable them to
Bring on record.
prepare. Bring on record means what? New documents. New documents, you cannot do it like this thing. You
No,
have to
because
do it by
I have received some PDF documents also, Lordship.
It's okay. You must see. You just take a printout. We'll just see what are the nature of
Yes, yes,
documents,
yes.
and then if there is any objection from other side, then we
Yes,
can
I'll
tell
take
you
the
by an
printout.
affidavit. But
I'll
there are
place it.
already enough affidavits here.
Yes.
You see, it will only increase the volume.
Yes.
Okay. Like so, place for grant of some time to enable them to compile some documents which may be needed for a final adjudication of this matter. I think that will do only compilation.
Yes, Lord.
But the learned counsel, the learned senior counsel for the petitioner has no objection. It's a prayer held list after a week. As part heard.
Yes, part heard.
As per her. Obliged, Lordship. Chalo. Oh,
No more.
2 and 3 connected. 2 and 3 are connected. Connected.
Just the three. Just you just say list.
Yes.
List on such and such.
Yes.
Same.
Say when this will come.
Same.
List after.
Yes.
It is already there. It's already
Yes,
there.
it's
So
already-
it's
it's
stacked.
already-
It's stacked together.
Stacked together.
It's stacked together.
List along with so and so.
Obliged, Lordship.
Okay.